All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Deborah K. Sundquist presiding.
You may be seated. Good morning. We're here on the Lund Voss versus City of Minneapolis Department and City of Minneapolis case, file number WC 236542. Today we are joined by Chief Judge Millen, Judge Quinn, Judge Christensen, and Judge Carlson. Counsel, you have been here before, correct? So you understand the rules, 15 minutes for oral argument. If you would like to reserve some time, Ms. Stewart, you can say so on the record and we'll try to get that in. So with that, if you're ready, Ms. Stewart.
May it please the court, counsel. This matter is before the court today on a very unusual procedural issue. It stems from a date of injury of August 3rd of 2020. There was an initial claim petition filed in February 8th of 2022. Then there was an amended claim petition alleging a new diagnosis of PTSD as well as an aggravation of the August 3rd, 2020 date of injury. There was a 2-day hearing before the compensation judge on June 21st and July 20th of 2023. The record closed August 18th of 2023 after written closings were submitted.
Counsel, I'm going to interrupt you for a minute because this is on a joint motion, and you're right, this is highly unusual in a procedural case. But as you can see, the full court is here today because we take this very seriously on the procedural issues moving forward on any case, and particularly because this is a case for us, a first impression that I'm aware of, to be up here on a joint motion. You both are up here on the same motion, correct?
That is correct.
And my understanding is that the pretrial statement that was filed was held the day before the hearing by telephone or by some other medium with the compensation judge and a representative from each party. Is that correct?
Your Honor, there was a telephonic pretrial. I don't have that specific date at hand. However,
I have it as the day before the hearing.
there was an amended pretrial statement filed the day before the hearing. Although if my memory serves me, I believe there was a telephonic pretrial prior to that date. There was a employee filed a pretrial statement before the day, an amended pretrial.
Yeah. And so I guess, and it goes to my question, the first time there was a discussion of a consequential injury for a secondary condition beyond the PTSD being let out was the day before the hearing. Is that going to be the answer of both you and defense counsel?
Yes, Judge.
Okay. And at that time, there was a conversation with the compensation judge that she would not be putting that issue on schedule for the first day of the hearing, which was scheduled the next day.
That conversation was held prior to going on the record on that June 21st. But yes, the context of the conversation is
Okay.
correct.
So you had two conversations off the record.
There was the amended pretrial statement the day before, and then on the day of the first day of hearing, the parties and the compensation judge had that conversation regarding the potential consequential.
Okay. And when you tried the case on two separate days, 2 different months, right?
That is correct.
Okay. And so the record closes on October 13th.
The record closed on August 18th after the submission of written closings.
I'm sorry, the findings in order were issued October 13th. My apologies. Okay. And the findings in order did not reference to a discussion to the pretrial that was by telephone or the off-record discussions.
That
Okay?
is correct.
Okay. So I go to page 151 of the hearing transcript. And on the record, the attorney for the employee states that she respectfully requests the opportunity to reserve the issue of a consequential injury for appeal should it become necessary.
That is correct.
Okay. And the compensation judge's response on the transcript is, okay, all right. Is that enough? It's reserved?
Your Honor, the parties are jointly requesting that it be acknowledged in the findings in order that the employee made the request, whether it's sufficient.
You don't want to take the risk.
Correct.
Because if it's not, then you've given up a consequential injury theory on an area of law that is being, well, viewed for the first time as it evolves.
Correct.
Fair enough? So you both come forward on a joint motion to ask me, this court, when I say me, the WCCA, to remand this and instruct the compensation judge to issue amended findings in order on the consequential injury that it was not to be pled out, and there would be no res judicata or collateral estoppel issue in the future.
I think the word instruct may be too harsh of a word here. Simply what happened after the findings in order were issued is the parties sent a correspondence to the compensation judge and asked, could we add the stipulated language, or could we add some language into an amended findings in order that reflect that the issue was reserved?
Okay, so, and the better word, and you're correct, would be this court would ask the CJ to explain
To explain
and
or
justify what was asked off the record.
to either explain or consider simply inserting the stipulated language into an amended findings in
Ms.
order.
Stewart,
Right, but
Why-
I just have one more question.
okay, I'm
Thank you.
sorry, I'm sorry.
What happens if the CJ doesn't agree with the language you've submitted? Are you coming back up here on appeal on other issues not resolved by the motion? If the motion is granted, but the language isn't to your liking?
I think the best answer would be potentially, and respondents to counsel and I have had discussions about what happens if the court decides not to insert our stipulated language. If there are no further discussions, the compensation judge did ask for stipulated language, and it might be quite presumptuous on my part to believe that she might consider adding something, even if it were not the initial draft of the stipulated language. But if ultimately she determines that she will not incorporate, will not amend the findings and orders to reflect the stipulated language, potentially there would be an appealable issue, and potentially you would see us again in the near future.
I have a
So
question.
clarification on the record is what you're seeking today.
Yes.
Okay.
I have a question, Ms. Stewart. What prevents the two of you getting together and stipulating what you'd like us to do today? I mean, what is the reason that you can't file a separate stipulation for settlement, for example, on the language that you're seeking?
I think, and I don't want to speak for respondents counsel, we have not discussed that particular solution. But my initial thoughts are with the dismissal of the claim petition in the city of Minneapolis, the respondent is also seeking clarification in the findings and order that the amended claim petition was dismissed with prejudice as well. But my initial thoughts on that are there would be concerns that with the dismissal of the amended claim petition, with the issue brought up at pretrial or in the pretrial disclosures, and then with the claim petitions being dismissed in its entirety, is that while respondent, I believe, would well be within its right to say, yes, we can stipulate to this, there would be some procedural issues for the employee, and for those reasons we're requesting just a clarification of the findings in order, so we don't run into those speed bumps in the future. To answer your question, nothing would preclude us from doing that, but I think that it would be potentially cleaner to have an amended findings in order.
Thank you.
With regard to the amended claim petition not being dismissed, was that just maybe a clerical oversight? That you would have expected the judge to dismiss both the claim petition and the amended claim petition, but just addressed one? Is that a fair
Based on-
summary?
Based on the findings and orders that were issued, that's what we presumed, but it would be speculative to say it was a clerical issue.
Okay.
There's still a current appeal that we're not discussing today, because you did appeal the findings and order of the compensation judge. Is that still an ongoing appeal in your mind?
To be completely candid, when the appeal was filed after the email exchanges between the various compensation judges, all issues were appealed to reserve. So as we stand here today, no, there's no ongoing appeal for the legal or factual findings.
Okay, as to what the judge decided.
That is correct.
Okay, your biggest concern is you want to be able to raise the consequential claim because you didn't get to raise it the first time and not be precluded from raising it because the claim petition was dismissed and the amended claim petition may or may not have been dismissed. It's just it's a procedural mess and you want to get it fixed.
Correct. Your Honors, this is a very unusual situation.
And that's why we wanted to do this, because we're a little confused too. So this is very helpful, quite honestly.
Well, I never thought I would quote my grandmother, but she always said, when you don't know, just say you don't know. And Your Honors, unless there are any further questions, I don't believe I need to reserve any time for a rebuttal, but I'm happy to answer any other questions you might have.
Thank you.
Thank you.
Thank you. Mr. Lindquist, when you're ready.
Thank you, Your Honors. May it please the court and counsel. My inclination here is to, at the risk of avoiding further confusion on this, to say nothing other than entertain questions that the panel may have.
Do you disagree with any of the responses to the questions that were asked?
I do not, Your Honor. I will say this for the record. What I wanted for my client was addressed by Ms. Stewart in response to Judge Carlson's question. I think that what my client wanted was the substance of the findings in order to be untouched. And I think that's why we cooperated with their request to do some amended findings, because that was part of the discussion. I know we don't have a record of that. We do now.
Okay.
That's all we wanted. And then we wanted to cooperate with Ms. Stewart's request to amend the findings. And from there, it's Sam's issue as far as I see.
And I'm going to ask you the same question that I asked Ms. Stewart. Why not just settle it between the two of you?
And to be fair, Your Honor, and that's a good question. I actually did discuss that option with Ms. Stewart's partner, with Ms. Rowland, who was initially involved in some of the discussions about getting an amended or stipulated finding inserted into the order. And we did talk about that as a possible procedural means. I didn't weigh in heavily on that because it wasn't my issue. I was just going to cooperate with whatever Ms. Stewart and her firm thought was the best way to get this issue accomplished. Obviously, we had hoped to get it done with the compensation judge, and some weird events intervened there to prevent us from doing that. I don't think any of us intended to come before this court with this kind of strange procedural issue, but here we are. From my perspective, where I sit here today, I would have no problem, if the court would prefer, in proceeding with the stipulation rather than asking this court to issue an order for a remand. I would add that I wouldn't envision this court remanding, to Judge Millen's point, remanding with an instruction to the trial court judge. I think that the discretion of whether to accept this stipulated language rests with the trial judge. I think we all agree on that. But if procedurally it's the preference of this court that we should proceed by way of a stipulation, order us to do so, and I would be happy to consider that.
Thank you. Any questions?
Thank you, Your Honors.
Thank you.
Thank you.
Ms. Stewart, would you like to use your rebuttal time?
No, Judge, I don't think I need it.
All right, thank you. Well, thank you, council. It's been very informative. I really appreciate you both being here today. This matter is adjourned. We will issue a decision within 90 days. Thank you.
Nicely done, Sam.
Recording stopped.